Good morning, everyone. Okay, my name is Tan Po Yi, Team Lead of Learning and Development of Halim Hong and Quek. Okay. Thank you, Sansuria, for inviting us to give this talk about corporate liability under Section 17A of the MECC Act 2009. Okay, I believe it's an important topic that is of concern, okay, not only to Sansuria, but to all commercial organizations in Malaysia. So before I go into the slides, okay, just let me share, okay, a recent case that's a charge under this Section 17A, okay, the first company in Malaysia to be charged under this section. Okay, so MECC has charged an offshore maintenance company named Pristine Offshore Sdn Bhd on 18 March 2021 under Section 17A of the MECC Act for offering a bribe of RM 321,350 to secure a subcontract from Petronas Carigali. MECC also charged the ex-director of the company, Chiu Ben Ben, for individual liability under Section 16 sub B subcapital A of the MECC Act 2009. The bribe was given to Huan Ismail, the Chief Operating Officer, COO, of Delium Primera Sdn Bhd, as a reward to ensure Pristine Offshore was awarded with subcontract from Petronas Carigali. So the offense was allegedly being committed between June 29 to October 14 of 2020 at a place in Puchong. Both the company and the ex-director had pleaded not guilty after the charges were read to them at Sessions Court, when where the current director of Pristine Offshore, Dato Abdul Kamal Muhammad Maidin, appeared on behalf of the company. So those both of accused were represented by Bernard Francis and Associates. So in this case, if Pristine Offshore is later found guilty under Section 17A, it may face a fine of not less than 10 times of the amount of bribe or prison for a term not exceeding 20 years. So for the ex-director, if later found to be guilty under Section 16, sub B, subcapital A, he can be imprisoned for up to 20 years and fined not less than 5 times of the amount of bribe. Since they did not plead guilty, so this was pending trial. So they post bail, and this case is pending disposal through trial later. So we will update you if of any future developments of this case, future outcome of this case, because I think this case will be of great importance, not only to Sansuria, but to corporate community as well. So without further ado, I will go to explain, further explain what is Section 17A of the MECC Act 2009. Go to my slides. Next slide. So what is corruption? So there's no statutory corruption definition of corruption. Malaysia Anti-Corruption Commission MECC has provided a definition to define corruption as follows. Corruption is the act of giving or receiving of any gratification or reward in the form of cash, in kind, of any value for performing a task in relation to his or her job description. So corruption can be in the form of money, cash, check, bank transfers, bonus, position, discount, reward, wage, service. Next slide. For example, a contractor rewards a gift in the form of an expensive watch to a government officer for awarding a project to the company belonging to the contractor. Next slide. So that is corruption lah. Okay. So what are the amendments made to the MACC Act? Okay, the Amendment Bill 2018 was first tabled in Parliament on 26 March 2018 and received royal assent on 27 April 2018, gazetted on 4 May 2018, and later takes effect on 1st June 2020. So this amendment, okay, introduces this new section called Section 17A, okay, to fulfill the international requirements under Article 26 of the United Nations Convention Against Corruption, UNCAC, to which Malaysia is a state party. Article 26, okay, of UNCAC states that each state party shall adopt such measures as may be necessary, consistent with its legal principle to establish the liability of legal persons for participation in the offences established in accordance with the convention. Next slide. Okay. So what are the offences under section 17A of the MACC Act? It states that a commercial organization commits an offence if a person associated with the commercial organization corruptly gives, agrees to give, promises, or offers to any person any gratification, whether for the benefit of that person or another person, with intent to A, obtain or retain business for the commercial organization, or B, to obtain or retain an advance in the conduct of business for the commercial organization. So this is the offense. Next slide. Okay, when there's the offense, of course, there will come the penalty, right? Okay, so the penalty upon conviction, okay, is stated in under subsection 2 of section 17A, which is fine. Okay, a fine liable to a fine of not less than 10 times of the amount of gratification, or 1 million, whichever is the higher. Okay, or jail, maximum 20 years, or both fine and jail. Okay, it can be and, it can be or, okay, it can be or, it can be and. So who can be imprisoned here? Okay, in the case where the corporate is found guilty later, senior personnel of the organization, okay, such as the director, controller, officer, partner, or person who is concerned with the management of a commercial organization. Okay, these are the people that will be sent to jail, okay, when a company is being found later guilty under section 17A. Okay, next slide. Okay, I give just an illustration, okay, to help you understand okay, the section. Baharudin bin Ahmad, okay, a YDP of Kanga Municipal Council, was accused of soliciting and receiving a bribe from a developer of a housing development project spanning approximately 10 acres in Padang Besar, Perlis. In return, he promised to approve, okay, as well as to ensure a smooth running of the project. So the bribe received from the developer was in the form of RM 30,000 in cash, 30,000 in check, okay, it's a cash check, okay, and a Mizano golf set worth 2,500. The courts handed down a sentence of 4 years imprisonment and a fine of RM 1.5 billion. Okay. Next slide. Okay, if charges are brought under section 17A of this MACC Act, who would be the court punishing? The YDP or the developer? Then you have to go back to the section 17A1 just now. Okay. So the answer is, next slide. Okay, is the developer. So what about the YDP as the recipient for gift? Okay, he cannot be charged under section 17A because 17A only says give, offer to give, promise to give. Okay, so the recipient, okay, of course, he cannot charge under section 17A, but he can still be charged under section 16, okay, or 17, okay, either he himself or as agent of the section 16 or 17 of the MECC Act. So that section says the person commits an offense if, being an agent, this is section 17, he corruptly gives or accepts or obtains for himself or for any other person any gratification as an inducement or reward for doing or forbearing to do, okay, any act in relation to his principal's affairs or business. Okay, next slide. Okay, so now important question. Who are the commercial organization under section 17A? It's defined under subsection 8, okay, of that section. So it includes company incorporated under the Companies Act 2016 and carry on business in Malaysia or elsewhere. Company wherever incorporated, okay, but carries on a business or part of the business in Malaysia. Okay, they can be incorporated outside Malaysia. Partnership formed under Partnership Act 1961 or under the LLP, okay, Limited Liability Partnership Act 2011, and carries on business in Malaysia and elsewhere. Partnership formed elsewhere outside Malaysia but carry on business in Malaysia. Okay, so these are the definition. These can be regarded as commercial organization. These are the companies that can be charged under section 17A. Okay, next slide. Then, if the company is charged, just now I have mentioned, okay, these are the persons who would deem to have committed the offense under section 17A sub 3. So who are they? Who are these people? When an offense is committed by a commercial organization, okay, a person who is the following position at the time of the offense, okay, who is a director, controller, officer, or partner, or who is concerned in the management of its affairs, is deemed to have committed the offense. Okay, now it's important to note that there must be first an offense against the commercial organization before this person can be charged, okay, for an offense. Next slide. Okay, then who are the associated person? If you remember just now, section 17A sub 1, okay, the associated person gives, promise to give, offer to give on behalf of the company. So who are this person? Can be director of the organization, partner of the organization, employee of the organization, persons who perform services on behalf or for the organization. Okay, there's no hard and fast rule of who this associated person is. So whether a person, okay, is found to be associated with a commercial organization will be determined, okay, to by reference to all the relevant circumstances. You have to see the facts, okay, not merely the relationship. Okay, so this will be, I would say, case-to-case basis. But if you see director, partner, will yes, normally yes, be. Okay, because some may be further than that. Let's say if agent. Okay, what about agent? What about vendor? What about your distributor? What about those? Okay, so that kind of relationship you have to see. Okay, what's the facts of the case, relevant circumstances, not merely the relationship. Okay. Next slide. Okay, definition of corrupt. Okay, as I've said just now, corruption is actually not no statutory definition, so it's important to refer to what the cases say. Okay, so it's defined as doing an act knowing that the act done is wrong. Okay, doing so with evil feelings and evil intentions. Okay, purposely doing an act which the law forbids. Okay, this as decided in this English case, R. and Smith, 1960. So if you see from here, corrupt is actually a question of intention. Not only the act, okay, but also the intention. If the circumstances show that what a person has done or has omitted to do was moved by an evil intention or a guilty mind, then he would be liable, okay, under that section. So if the accused used his position to solicit gratification, okay, with the guilty mind, then he may be caught under the ambit of the section. Okay, so question of intention. It goes back to not only the act, but the intention as well. Next slide. Okay, gratification. What is gratification? Okay, it was defined, explained under section 3 of the MECC Act. Okay, there are a long list of these examples. Okay, of course, money, okay, donation, gift, loan, fee, reward, valuable security, property, interest in property, okay, being property of any description, okay, whether movable property, immovable property, financial benefit, okay, or similar benefit, or similar one. So any office, okay, employment, dignity, contract of employment, okay, position, okay, or service or agreement to give employment or render service in any capacity. Okay, it can also be any payment, release, discharge, okay, or liquidation of any loan, obligation, or other liability, whether in whole or in part. Okay, so these are, next slide. Okay, and some more, okay, long list some more. Any valuable consideration, discount, commission, rebate, bonus, deduction, or percentage, any forbearance to demand money, that is also considered as gratification. Any service, including protection from any penalty, okay, or protection from any action or proceedings, any offer, undertaking, or promise, okay, these are all can be regarded as gratification. So not only money, okay. Next slide. Okay, defense. Okay, once a company, a commercial organization being charged under section 17A, what defense it can raise? Okay, if a commercial organization is charged for offense, okay, referred to in subsection 1, 17A sub 1, it is a defense for the commercial organization to prove that the organization had in place adequate procedure to prevent persons associated with the commercial organization from undertaking such conduct. Okay, so had in place adequate procedure, okay, which we will go later. We will go in detail, okay, later. What are the adequate procedure, yeah? Next slide. Okay, what about defense for directors, controller? Because they are deemed to have committed, right? So it will be a defense if they can raise that the offense was committed without his or her consent and he has exercised due diligence to prevent, okay, the commission of the offense, okay, as he ought to have exercised, taking into account his function, okay, his capacity and the circumstances. Okay, not all, and not only without his consent, then he has exercised due diligence to prevent commission. Okay, next slide. Okay, if a director commits offense, commits corruption out of pressure to pay, will the defense of committed the act without his consent apply? Okay, as I said earlier, okay, section 17A has not been tested. Okay, but also try to find out what are the meaning without his consent. Okay, arguable, okay, quite arguable. So there's this recent case, Dato Muhammad Farid bin Muhammad Ali, okay, against Dato Nasir Hussein bin Akhtar Hussein against others, okay, 2021 case. This is not section 17A, but this under section 16 for giving bribe. Okay, the plaintiff contended that he's pressured to pay money to the first and second defendants because the plaintiff believed that in return for payment of money, investigation by MCC, okay, against this plaintiff would be halted. He believed okay, first and second defendants have influence over the MACC. They will be able to influence or persuade MACC not to proceed with investigations against plaintiff. Okay, plaintiff was pressured to pay, but he know fully aware what's the purpose of payment, right? Okay, so in that case, the court held that he is a voluntary participant to the illegal act. Okay, so it is considered as with his consent. He cannot say that the act was without his consent because he was fully aware what's the purpose of that payment. Okay, and he's fully aware what he will obtain from that payment. Okay, so he cannot say that from there he's pressured to pay, that he never willing to pay, that that act was without his consent. So it doesn't go that way lah. Okay, next slide. Okay, just to explore further other laws related to corruption. Okay, so in the matter of disclosure and privilege, okay, under the general rule, okay, it's under Evidence Act 1950, Section 126. Okay, communication between advocate and solicitor, a lawyer and client, are generally protected under legal professional privilege. They are not required to, cannot be compelled to tell, okay, if there's any investigation, what are the communication between lawyer and the client, because they are protected under this privilege. Advocate and solicitor are strictly restricted to disclose confidential information unless express given by the client. They always have to go back to the client to ask whether client give that permission or not. But okay, you compare that under Section 46 of the MECC Act. Okay, under this act, advocate and solicitor will be compelled to disclose information in respect of any transaction or dealing relating to any property which is liable to seizure. However, if the information is for purpose of pending proceeding, then the advocate solicitor cannot be compelled to disclose. Okay, provided if it's pending proceeding. Okay, next slide. Okay. Apart from Evidence Act, the general rule on the disclosure and privilege, whistleblower also, okay? Whistleblower, okay, is generally protected under Section 7 and 10 of the Whistleblower Protection Act 2010, okay? Protection of confidential information, okay? Whatever the information that they give will be protected. They won't be sued, okay, immune from civil and criminal action. You cannot take action against the whistleblower for giving the information. Protection against detrimental action against them. Okay, detrimental could be in the form of like workplace, okay, promotion, or any action that would detriment, okay, the whistleblower. Okay, but if you refer to Section 65 of the MECC Act, identity of information or the place in which the information was given by the informant, the whistleblower, to MACC cannot be revealed or disclosed in any civil, criminal, or other proceedings in any court. Okay, so these are quite, I would say, quite consistent. That means you cannot, whatever the informant, that means the whistleblower give, you cannot reveal or disclose in any proceedings in court. No only court, but tribunal or any other authority. Okay, and next slide. Okay. Witness protection. Okay, witness protection is also if they are agree to be witness, okay, for the prosecution, then they would be protected. The identity will be protected under this Witness Protection Act 2009. Okay, so who is a witness there? Under this act, okay, it states who are the witness. Okay, it includes a person who has given or agreed to give evidence on behalf of the government in a criminal proceeding or the commission of an offense. Okay, or a person who has provided any information to the authority in relation to an offense. Okay, that offense would include the offense under MECC Act. Okay, information relevant, okay, to witness will be submitted to the Witness Protection Unit. There's a unit under this Prime Minister's office to protect the information given by these witnesses. Okay, they will be registered. Okay, register of this witness. Okay, and the information that they have given. and no proceedings can be taken against these persons who provides the information. Okay, so just a little bit of information about this Witness Protection Act. Next slide. Okay, data privacy. This is also important aspect. Okay, general rule under Personal Data Protection Act (PDPA) 2010 prohibits the disclosure of personal data without the subject's consent. Okay, that's the general rule. Next slide. Under Section 31A B, okay, A and B of MACC Act 2009. This is an act where during investigation, okay, because if there's a complaint of any offense, then the MACC have to start their investigation. So during investigation, okay, what these officers can do, okay, of the commission, they may order any person to attend for examination, okay, which in his opinion will assist in the investigation. Okay, order any person to produce any book, not only ask, okay, not only examine, question him, but also ask for any books or records or statements or okay, accounts, which in his opinion will assist in the investigation. Okay, and they will have to issue a written notice, okay, to any person to furnish that statement, okay, on oath or affirmation, setting the information. What are the information they want? Okay, so this was discussed in this case of SPRM against Latifa Koya, okay, in 2017. Okay, all right, it's a federal court decision on that. Okay, next slide. Okay, Section 36(1)A and B. Okay, this one is 30. This one 36. After the investigation, if MACC believes that any property was acquired by a person as a result of committing an offense under the MACC Act, the commissioner may issue a notice, okay, request for an affirmation or statement on oath, okay, of any person under investigation, okay, or any relative of that person, okay, who the authorities can help with the investigation, okay, or require any bank or financial institution to furnish copies of documents, okay, and records in relation to any person under investigation. This is if they believe any property was acquired as a result of the offense. Okay, next slide. Section 43, also relevant section, it provides the MACC with the power to intercept, detain, open any postal article in course of transmission by post. Okay, it will stop the post first before it reach you. Okay, open, detain what is inside that post. Okay, intercept any message transmitted or received by telecommunication. You can tap your conversation. Okay, intercept, listen, or record, okay, and conversation by telecommunication, and listen to the recording of the intercepted conversation. Section, okay, next slide. Section 47, okay, of the Act provides MACC the power to request any person to give any information on any subject which is such duties officer to inquire into. Okay, next slide. Okay, before, okay, so just now from those sections, 30, 36, 43, 47, we see that, okay, under MCC Act, okay, they will overwrite, okay, what was provided under the general rule under PDPA. Okay, so during investigation, this is the power that they have. They can so-called interrupt, okay, or on the personal privacy, okay, of the, can get your data. So that's what the power of the under the MCC that it can do lah. Okay, okay. So just now we have mentioned about Section 17A sub 4, right? Defense of the commercial organization to prove that the commercial organization already had in place an adequate procedure to prevent persons associated with the commercial organization from undertaking corrupt conduct. Okay, so we'll zoom in. What are the adequate procedures? Next slide. Okay, so how do commercial organizations know whether the system they have is adequate? Okay, so there's this guideline laid out under in the Prime Minister's Department on 4 December 2018. It's called the trust, TRUST principles. Okay, so T stands for top level commitment. Okay, R stands for risk management. U represents undertaking control measure. Okay, S stands for systematic review, monitoring and enforcement, and T, of course, is training and communication. So these are we call the trust principle. Okay, next slide. Okay, we'll zoom in one by one. Top level commitment, of course. Okay, these are important commitment for a company. Okay, if we still want to survive, these are the top. It has to start from the top level commitment. So the top level commitment, they are responsible to ensure that the commercial organization practice the highest level of integrity and ethics. This is important, okay, because they are the one setting an example to the rest of the organizations, okay, and also comply with the applicable law and regulatory requirement, okay, on anti-corruption, and effectively manage the key corruption risk in the organization. Next slide. Okay, so to do this, organizations, okay, should carry out the following. Okay, establish, these are the big picture I'm giving, establish, maintain, and periodically review the compliance, whether comply or not. Okay, you have to promote a culture of integrity within the organization, and it has to start from the top. Okay, communicate policies not only to internal, to external parties as well. Okay, so all parties will know, okay, what is your stand, what is the policy, what is your stand on this. Encourage use of a secure reporting channel. Okay, whistleblowing, if they want to report, okay, of any incident, okay, you must make sure that they will feel safe to report. Okay, if there's any backlash against them, who will want to report? Okay, so it must be a secure reporting channel. Assign a competent person, okay, call it an officer, to provide guidance and ensuring compliance of the program. Okay, compliance officer. Clear line of authority, okay, or to oversee the program. You must know like who okay, reports to who. You must know who to report to, or if there's any more than one officer to report to, okay, in charge of what. Okay, so this line and the scope of what has to be clear. Periodic review, this is important. Okay, risk assessment, control, and performance. You have to review periodically. Ensure that the results of any audit, review, or risk assessment, okay, control measures and performance are reported to the top level. The top level must know results of any audit, review, or control measures or performance, whether comply or not. Okay, next slide. Okay, risk assessment, okay, the second principle just now. Okay, it's recommended, okay, every 3 years with intermittent assessment. Okay, it means in between the 3 years can be smaller assessment, okay, which they may focus, okay, on the following. Okay, these are recommended lah. Opportunities for corruption. That means area of it depends on the nature of the business of the company, where they have to identify, okay, which are the area where there will be high risk, okay, for corruption, high opportunity for corruption and fraud activities. Okay, they have identified that. Commercial transaction, which may disguise as corrupt payment. Okay, business activities, okay, they deal with a lot of parties or sectors that will pose higher corruption risks. They have to identify that. Non-compliance of external parties, okay, maybe they not, but their partners may, okay, or have a risk of doing this corrupting. Relationship with third party in its supply chain, okay, which are likely to expose the commercial organization to corruption. Okay, so these are the risks, the possible risks which the company needs to assess, okay, and identify. Next slide. Okay, the third principle, undertake control measures, okay, which may include the following. Okay, again, these are recommended, okay, recommendations guideline. Due diligence through background check. Okay, these are ways of control You do background check. Okay, do you deal with the party? Do background check. Document verification process, supporting document you have to go through. Okay, checklist. Conduct interviews with the person if need to. Okay, establish an accessible and trusted whistleblowing channel, as I have already mentioned just now. Okay, not only secure means accessible, easy to access, and also trusted. They will feel secure. Whistleblowing identity must be protected, and no retaliation, okay, against them for making reports in good faith. establish policy and procedure that covers general anti-bribery and corruption policy. Okay, have a policy, conflict of interest check, give, entertainment, travel, donations, sponsorship, felicitation payment, financial or non-financial control, and record keeping. And these are, there must be a policy regarding this, okay, all these things. And all this must be endorsed by top level. No need endorse, it must be kept up to date. Okay, that's why review is important. You have to update and easily available. Okay, next slide. Okay, systematic review, the fourth principle, okay, monitoring and enforcement. It can take the form of an internal or external audit. Okay, establish a monitoring program which covers the scope, frequency, and methods of review. How do you review it? You have a policy. What do you review? How frequent you review? Okay, how you do your review? Okay, identify a competent person to perform internal audit. Okay, continued evaluation and improvement on policies and procedures related to corruption. Consider external audit by a qualified and independent third party, at least once every 3 years. Monitor performance of relevant personnel. Okay, and of course, the last one, disciplinary proceedings in case of non-compliance. Okay, yeah, otherwise they won't see the bite. Next slide. Okay, and the last principle, training and communication. Okay, training is important, should provide its employees and business associates adequate training. So this training can be in various formats. It can be an induction through an induction program, corporate training program, seminar, video, intranets or website, town hall session. Okay, it can be through retreats and during outreach program. Okay, these are just to name a few. Okay, a few of the formats. Next slide. Okay, communication of policies. Okay, should be made publicly available, as I mentioned just now. Okay, should take into account what, who, how, when, and what language to publish. Okay, depends on nature of the company. Okay, can be communicated in various formats. It can be through email, message, okay, of the memo, intranet, newsletter, poster, okay, code of business conduct, employee handbook, video, seminar, or town hall sessions. Okay, next slide. Okay, that's the guideline for adequate procedure. Okay, so these are my presentations. Okay, is there any? I will pass the floor to the MC.
Okay, thank you, Ms. Tampoyi, for the enlightening sharing. I'm sure that is very helpful to many, especially our attendees today. And now we have come to the question and answer section for this webinar. Before we proceed, we would like to invite Ms. Chong Li Hui and Mr. Thoo Huan, our senior partners in Halim Hong and Quet, to join us for the Q&A section. So before we start, there are some general questions that may have arisen, of which we think is very important. So let me start with the first question. The first question is, can a director of a company be liable under the Act if he agrees to give bribe to a third party for the benefit of the company without actually giving the bribe? So this question will be answered by Mr. Thoo.
Morning to everyone. A good question. I think the key word in the question is when the action itself is without an actor's risk. That means there is an element of mens rea, intention, but however, there was no actual conduct of giving the bribe. So is this amount to an offense under the MACC Act? I think one can refer to the parent act itself, i.e. the MACC Act, which suggests that there are specific provision to say that a promise to give is an amount that can be found in the section 16 as well, whereby the word offense clearly stated the word promise to offer. That means that it suggests that even though there is no actual bribe being given, the intention or an attempt to give does amount to a bribery offense. And then the MACC may open a file and investigate, and then may consider to charge pursuant to the MACC Act. Yeah, Koi, any other questions?
All right. Thank you, Mr. Thoo, for answering the first question. I'm sure that it will be very helpful to the attendees today. Now let us move on to question 2. This question is, must the company be charged under the section 17A first before the company's directors or officers be charged under section 17A subsection 3? So this question will be answered by Ms. Chong.
Oh, okay. Section 17A, right, is as everyone know, is designated as a corporate liability provisions. So yes, there must be a charge against the company first under section 17A, okay, and then only the company directors or officer can be charged under section 17A3.
Right. Thank you, Ms. Chong, for answering this question. I hope that clears the doubt. Right, let us move on to question 3. If an employee of a company B gives bribe to an officer of company C for the benefit of company B, can the employee be charged under section 17A of the MACC Act? So this question will be answered by Ms. Chong.
Okay, the employee is employee of a company B. It gives bribes to the officer of company C for the benefit of company B. Okay, so can the employee of a company B be charged under 17A? Yeah? Okay, for employee, right? Okay, an employee, right, is an associated person as defined under section 17A6 of the MACC Act. So the Employees Act of giving bribe for the benefit of company B, for company B, that means his own company, it can cause the company B to be charged under section 17A, okay, but the employee itself, right, it will not be charged under 17A, but it will be charged individually under section 16(1)(b) of the MACC Act for giving bribe, okay, for the offense of giving bribe for the benefit of his company. Okay, that's the answer. This is my answer.
Right. Thanks, Ms. Chong, for answering this question. Now let us move on to question 4. The question is, Company A is a foreign entity investing in Malaysia. It enters into a joint venture business with a local Malaysian partner. If the local partner commits bribery in pursuit of projects for the joint venture, will Company A be liable for prosecution under section 17A? And this question will be answered by Mr. Thoo. Hi, Mr. Thoo. We actually couldn't hear your answer just now. Can you please unmute yourself? Yeah, thank you.
Sorry, Koi. As I mentioned just now, based on the question, the key element that we need to consider is how we define the associated person. As you can find out from the section 17A sub 6. A person is associated with a commercial organization if he is a director, partner, or an employee of the commercial organization, or there's a sweeping provision behind there, whereby it covers any person who perform services for, on, or behalf of the commercial organization. So if you refer to this definition of associate person, the coverage is very wide. The answer to your question, Kwai just now, is that yes, it can be considered associated person, whereby it can be charged, the commercial organization can be charged under Section 17A, as long as the company A, regardless of what being labeled of their relationship, as long as there is a relationship, the Act will have the effect of implicating the commercial organization. That will answer my question. That's my answer to your question, Kwai.
Right. Thank you, Mr. Thoo, for answering question 4. I hope it is very useful to all the attendees today. So, dear all, you may also post your question in Q&A. Yes. Yes.
I think before that, I think there's one question being posed just now.
Yeah.
There's one question being posed just now.
Okay. So
whereby a participant had asked whether it is safe for a commercial organization to give charitable donation to a government organization. I think the answer is the general answer to this is there's a prohibition for a commercial organization to give any donation to a public body. That is a general answer. But in the event that the government organization charitable event was actually being permitted or being consented by their top management as a charitable event or being permitted, then the commercial organization it has their own of giving out the charity itself, whether there any provision to prohibit such a charitable event. And to give a better understanding of this donation part, I think there is one case in UK, the A-Bus case, the well-known A-Bus case, whereby the A-Bus company, this is a UK case, the A-Bus company has sponsored A-Asia, a sport team owned by the A-Asia. And based on the findings by the investigation officer from the email, later on, A-Bus, then the government authority has accordingly charged A-Asia for such corruption being conducted in their business deal.
Right. Thanks, Mr. Thoo, for answering this question. I'm sure that it is very useful as well to all the attendees today. So let us move on to the question and answer chat box as well. You may also post your question in the chat box if you have any question. So let us refer to one of the questions here posted by Miss Adeline Lee. So will the company B director will be charged under Section 17? So this question was referring back to our general question 3, which was answered by Ms. Chong just now. Ms. Chong, can you hear us now? Hi, Ms. Chong. Yeah, we actually couldn't hear your voice.
Technical issues here. Can you hear me now?
Yes, yes, very clear. Thanks, Ms. Chong.
Yes, yes. Okay, sorry about that. Okay. So yeah, where the company B director will be charged under section 717A. Yes, the company director will be charged under section 17A as well. Okay. Even okay, of course he can claim the defense of the act of the wrongdoing is without his knowledge and consent. But this act is reverse the burden of proof. Okay, we used to know that the general principle is right. Okay, you are innocent until you are proven guilty. But for this 17A, right? Okay, you are actually be guilty. Okay, deemed guilty. Okay, unless you are proven unless you are being proven innocent. So yes, okay, company B director will be charged under section 17A as well. Okay.
Thanks, Ms. Chong, for answering this question.